In the series of lectures on professional conduct and professional ethics, already in regards to legal profession, already we have discussed in two previous lectures the very origin of legal profession, its meaning and development in India, and in the second lectures we have discussed regarding the very legal ethics, what it means, and the meaning defining professional conduct as per the provisions of Advocates Act 1961 and the rules framed by the Bar Council of India. And in our third lecture, we would like to discuss regarding professional misconduct and the very punishment for breach of professional conduct. So, in regards to that, we would like to discuss what the very definition of professional misconduct, the very term misconduct is a wide expression. Misconduct, as defined in Black's Law Dictionary, as a transgression of some established and definite rule of action forbidden by act, improper, unlawful, or wrong behavior, and impropriety or mismanagement. And as it is defined in certain leading cases, such as in state of Punjab versus Ram Singh in 1992, Supreme Court almost upheld the definition given in the Black's Law Dictionary and opined that mere error of judgment, carelessness, or negligence in performance of duty does not constitute a misconduct. Besides the above, it involves moral turpitude, actions likely to tamper or embrace the administration of justice, unprofessional acts with a wrong intention and deviation from duty, as it was opined by the Supreme Court in this important leading case in state of Punjab versus Ram Singh in 1992. And in another important leading case, that is in PD Khandalkar versus Bar Council of Maharashtra in 1984, Supreme Court approved the definition of justice Lopez given in 1894 in the decision delivered by the Queen's Bench, where Justice Lopez, in the leading case, Allison's versus General Council of Medical Education and Registration, hold that man in pursuit of his profession has done something which will be reasonably regarded as disgraceful or dishonorable is guilty of infamous conduct in a professional respect. Also, Justice Darling held a similar view in the leading case, George Fire Graham versus Attorney General of Fiji in 1912 in the King's Bench. Also, Chief Justice Pez in a 1934 case in the Privy Council laid down to test, namely, Wing, unworthy to remain as a member of the honorable profession and being unfit to be entrusted with the responsible duties of an advocate. The courts dealing with cases of professional misconduct is not concerned with ordinary legal right but with the special and rigid rules of professional conduct expected of and applied to specifically privileged class of persons who, because of their privileged status, are subject to certain disabilities which do not attach to other man is bound to conduct himself in a manner befitting the high and honorable profession he has been admitted So, in that connection, we would like to discuss the very provisions of the Advocates Act, Chapter 5th of Advocates Act 1961 under the heading Conduct of Advocates consists from Section 35 to Section 44, which make provisions to carry out disciplinary proceedings against an advocate for professional misconduct. To implement these provisions, the Bar Council of India made rules under Chapter 1 and Chapter 2 of Part 7, as Section 35 provides punishment of advocates for misconduct, and to carry out the provisions under this section as per Rule 1 to Rule 17 under Chapter 1, Part 7, from dealing with procedure of complaint and inquiry. The complaint shall be in the form of a petition supported by an affidavit, and the language shall be in English. Further, it shall be accompanied by a certain fees and an additional fees for the cost of service of processing. But a court, tribunal, and other statutory bodies are being exempted of these fees under Rule 1 of Part 8 of the DCI rules. After receiving the complaint, the registrar shall immediately send a show cause notice to the advocate to submit the statement of defense with documents and affidavits. The advocate can appear in person or through duly authorized representative. In case of his non-appearance, the matter shall had and determined in his absence. The chairman of the disciplinary committee within 30 days shall fix the date, hour, and place of inquiry. Then the registrar shall give notice to that effect to the complainant, the advocate concerned, and the attorney general or additional solicitor general or the advocate general, as the case may. Further, the parties can appear in person or by an advocate who should file a vakalatnama, and in case either of the two does not appear, in spite of service of notice, the committee may proceed ex parte regarding withdrawal of disciplinary proceeding by the Bar Council of India under Section 36, subsection 2 of the Act. The very rule under 18, Chapter 1 of Part 7, laid down procedure for such withdrawal. The disciplinary committee of the Bar Council of India may call for a report of the disciplinary committee of the concerned state bar council, which may issue notice to the respondent, may require the parties to file such statements as it considers necessary, may call for the records of the proceedings, and may examine any witness before any such withdrawal. Rule 19 to Rule 28 provides the procedure to be followed in all cases of appeal to the Bar Council of India under Section 37 of the Act. These are the appeal shall be in the form of a memorandum and shall be in English. The appeal memorandum shall accompany copy of the order signed by the registrar and with necessary fees under Rule 2, Part 8. Further, the parties in appeal can appear personally or through an advocate who should file a vakalatnama. An appeal shall not be permitted to be withdrawn on account of settlement or compromise or adjustment of the claim against the advocate. The appeal shall await on the death of the advocate only. On any application for stay under Section 40 of the Act, Rule 29 laid down such procedure to be followed for stay. An application for stay shall accompany an affidavit and fees as per Rule 2 of Part 8. Rule 34 provides the procedure on inspection of records and copies. All parties in the any disciplinary proceeding are entitled to inspection of records and copies concerning such proceeding. The application shall be made to the register, duly signed by the applicant and accompany a fee for inspection at any stage of the proceeding, and decided by the proceedings further no such record shall be made. Xerox copies only, short notes in pencil is allowed. Rule 1 to Rule 7 of Chapter 2 of Part 7 states the procedure regarding review of the orders of the disciplinary committee of a bar council as per the provisions under Section 44 of the Act. An application for review shall be in the form of a petition supported by an affidavit accompanied by a fee under Rule 2 of Part 8 and shall be filed within 15 days from the date of the order to be reviewed. The review petition shall accompany copy of the order, shall state the grounds of such review and shall state filing pending or the result of any petition filed in any proceeding in respect to the said order. Lastly, Rule 36 of Chapter 1 of Part 7 clearly states that the Secretary of the State Bar Council or the Bar Council of India shall send the copies of final orders to each of the parties without any charges for the same. So, punishment for breach of duties consisting Rule 1 to Rule 52 of Chapter 2 under Part 6 should be examined with due reference to Section 35, Section 36, Section 36B, Section 37, Section 38, Section 40, Section 42, and Section 44 of the Advocates Act 1961. For better understanding the analysis of rules under Part 7 and the fee structure as provided under Part 8 should be duly examined. So, in that connection, we would like to discuss certain important leading case relating to professional misconduct and punishment. So, the first important leading case that we would like to discuss is PC Chaturvedi versus State Bar Council of Uttar Pradesh, which was decided in 1977 by the Allahabad High Court. So, under Section 35 of the Advocates Act, it is the Bar Council at the preliminary stage has to test the probative strength of the evidence and also before taking action, as observed by the Honorable Allahabad High Court. Probative strength means whenever the law requires any authority or person to take action when he has reason to believe that the circumstances under which the action should be taken are present or in existence, then those facts and circumstances must come within his knowledge, and also there must be some material which should help in recording a finding or establishing those circumstances of fact. So reason to believe should not mean beginning of any proceeding merely on a hearsay information which would be nothing more than a gossip or a rumor going around in the corridors of the court to form an opinion regarding guilty of professional misconduct. So, what is required by law is the presence of material facts which with some certainty would lead to conclusion that the misconduct was actually committed and there was some credible evidence in support of it on the record. The wisdom of the legislature is clearly seen as whenever the statute required an action to be taken on reasonable belief, it does not permit any action to be taken only with a view to find out the guilty after roving inquiry. So, after this observation by the Allahabad High Court, now we would like to discuss another important leading case, that is Narendra Singh versus Chotrai Singh, which was decided by the Supreme Court in 1983. And in the very judgment, the disciplinary committee of the Bar Council of India, while hearing an appeal under Section 37, has the power to remand the matter to the disciplinary committee as observed by their Honorable Supreme Court and that of the State Bar Council. The principle of atrophious acuity or convict does not govern such proceedings. Acuity means previous acquittal or conviction by a competent court of law is a bar to further prosecution for the same offense, as it was observed in connection to Article 20, Clause 2 of the Constitution of India, and also as reference to Section 300 of the Criminal Procedure Code, as it was observed by their Lordship of the Supreme Court. Now we would like to discuss another important leading case, and that is P.D. Khanderkar versus State Bar Council of Maharashtra, and it was decided by the Supreme Court in 1984. And the very observation has made appeal under Section 38, the Supreme Court would not, as a general rule, interfere with this concurrent finding of fact by the disciplinary committee of the Bar Council unless the finding is based on no evidence or it proceeds on mere conjecture and unwarranted interference. And now we would like to discuss another important leading case, that is Bar Council of India versus Manikant Tiwari, which was decided by the Allahabad High Court in 1983, where it was observed Section 48 says no suit or other legal proceedings shall lie against any member of or against the Bar Council or the committee for any act done in good faith or intended to be done in pursuance of the provisions of this act or of any rule made thereunder. In case the act complained against is not an exercise of discretion, but on the contrary proceeded from a corrupt, malicious, or improper motive, the person aggrieved may seek relief in a court of law, as the act done as per the provisions of this section is not done in good faith as it was observed by their Honorable Allahabad High Court. And now we would like to discuss another important leading case relating to professional misconduct and punishment, and that is Bar Council of Kerala versus Thankapana Pillai in 1986 by the Kerala High Court. As it was held, Section 48A of the Advocates Act gives the Bar Council of India the power of revision of any proceeding, disposal by a state bar council or a committee thereof for the purpose of satisfying itself as to the legality and propriety of such disposal, and may pass adas in relation thereto as it may think fit. So, this revisional authority of the Bar Council of India was inherent jurisdiction to pass interim orders pending a revision. So, these are the important leading cases that relating to professional misconduct and punishment. And now we would like to discuss exactly what are the punishment for breach of professional conduct. The Advocates Act under different sections provides the constitution, formation, scope and jurisdiction of disciplinary committee or committees to punish advocates for the violation of the above discussed duties. That already we have discussed. And Section 9 of the Advocates Act provides the constitution and formation of disciplinary committee or committees, while Section 42 deals with the powers of the disciplinary committee of a bar council. Section 36 provides the disciplinary powers of the Bar Council of India on the question of punishment for misconduct. The State Bar Council enjoys various powers under Section 35 of the Advocates Act 1961 regarding disposal of any complaint appeal to the Bar Council of India and appeal in the Supreme Court as per Section 36B. Section 37 and Section 38 may be examined in detail. Stay and review of such orders are under the provisions of Section 40 and Section 44 of the Advocates Act 1961. For proper implementation of this section, the Bar Council of India under its powers to make rules framed 36 rules under the heading Disciplinary Proceedings and Review. These rules cover the procedure and method to be followed by the disciplinary committee of the State Bar Council and the Bar Council of India. These rules also cover the procedures of withdrawal of proceedings, appeal to the Bar Council, application for stay, and inspection of records and copies. And as per Rule 30A of Chapter 1 of Part 7 regarding punishment for breach, the disciplinary committee enjoys the power of a civil court under the Code of Civil Procedure 1908. So it can summon and enforce the attendance of any person and examine and him on oath, requiring discovery and production of any documents, receiving evidence on affidavits, issuing commissions for the examination of witnesses or documents, and can cull any public record or copies thereof from any court or office. All proceedings shall be deemed to be judicial proceedings as for the provisions of Section 193A and Section 228 of Indian Penal Code. All disciplinary proceedings shall be concluded within a period of 1 year from the date of the receipt of the complaint or the date of initiation of the proceedings, following which such proceedings shall stand transferred to the Bar Council of India. Regarding the punishment, the advocate may be simply warned of his misconduct, may be suspended from practice for a specific period, and during that period of suspension is being debarred from practicing in any court or before any authority or person in India, and may remove the name of the advocate from the state rule of advocates. Further, under Section 37, an appeal can be made to the Bar Council of India against the order of the disciplinary committee of a state bar council, as it was held in the leading case by the Supreme Court, Narendra Singh versus Chotra Singh in 1983, and within 60 days of the date of communication of any such order. Section 38 provides an appeal to the Supreme Court against the order made by the Disciplinary Committee of the Bar Council of India within 60 days of the date on which the order is communicated, and this very ruling was held in several important leading cases by the Supreme Court of India, and such leading cases are VC Rangdurai versus Gopalan in 1979 by the Supreme Court, Solso in the leading case, P.D. Khandekar versus Bar Council of Maharashtra in 1984, Solso in the leading case, Bar Council of India versus Manikanti Ori by the Allahabad High Court, Solso in the leading case, Bar Council of Kerala versus Thankapana Pillai in 1986 by the Kerala High Court. So finally, all proceedings before the disciplinary committee shall be held in camera as per the rule 33 of chapter 1 of part 7. So the very conclusion that we would like to make on the very topic professional misconduct and punishment. Punishment for breach of duties as provided under the Advocates Act and BCI rules are the fermenting ground of many controversies. As society is rapidly changing, so also the character and nature of the profession. Legal profession is the royal profession. Its demand in every sphere is increasing rapidly as administration of justice is its sole and only concern. The professionals engaged in the field urgently need some new safeguards and protections because, in the name of professional ethics, they are being debarred to carry out certain functions which are demanded largely under the new parameters of globalization and liberalization. The trend of globalization and liberalization urgently require the legal expertise of the professionals engaged in the field of law. Globalization and liberalization paved the path for opening of many new avenues. The foreign direct investment and the foreign institutional investments are largely flowing to the country. The flow of FDI and FII facilitated the arrival of multinational corporations and large retailers. So the process of business outsourcing and knowledge outsourcing are in greater demand. The developments in the field of industry, science, technology, and information technology, etc., urgently require the service and knowledge of the legal professionals. The laws on contract, banking, company, insurance, IT, and cyber laws have major roles to play. Besides this, the civil, criminal, and international laws also have greater perspective. All these would be mere dream without the active participation and contribution of the legal professionals. The process of knowledge outsourcing will greatly benefit the legal community. But with the present provisions of the Advocates Act and Bar Council of India rules, the legal community is helpless to involve itself in the process of globalization. The present canons of professional ethics are the real obstacles for such participation. Knowledge outsourcing by the lawyers will be considered as violation of professional ethics and will draw punishment for such activities as at present this will be taken as misconduct. So in the present scenario, the legislature, the executive and the judiciary in India should give some real thought to amend and codify the provisions of the Advocates Act and the rules framed by the Bar Council of India on the subject dealing professional misconduct and punishment for breach. Otherwise, the fruits of globalization will not reach all corners and conscience. As administration of justice is the cornerstone of each and every activity of the community, and the lawyers are the only and ultimate harbingers to realize this shame, so they should be little bit free from the so-called canons of professional ethics. At the same time, Indian lawyers, instead of opposing arrival of foreign legal community and legal firms, should welcome them into the Indian legal scenario. This will enable the to create an atmosphere of healthy competition and exchange of new ideas and developments in international legal profession. So the community of legal professionals in India should come above all narrow and limited apprehensions. So in this lecture we have completed the very discussion relating to what is professional misconduct and what are the punishment for breach of professional conduct as provided under the Advocates Act 1961 in relation to those rules framed by the Bar Council of India in constituting the disciplinary committee and the very power to appeal to the Bar Council of India from the rulings of State Bar Council and finally appeal to the Supreme Court of India. And besides that, we have discussed a conclusion relating to professional misconduct and punishment.